Hello to our Rise Up audience. Welcome to this webinar called Navigating the Legal Landscape for Christian Educators. We're so excited you're here, and we're just waiting for people to come on in. And if you're in, go ahead and introduce yourself in the chat. Go ahead and share your name and where you're from. My name is David Schmoose. I'm with Christian Educators Association International. I'm the Executive Director of CEAI. And we are an organization that's been around since 1953. We serve members in all 50 states. We provide a suite of legal services and also ministry training for educators, largely in our public schools. We also have private school members as well. We offer an alternative to unions. So if teachers do not like their unions, they can join Christian Educators. And we offer $2 million professional liability insurance, job protection benefits, unlimited legal and educational consultation. So we often are a first line of defense for Christian educators in our public schools who may face challenges to their faith, or just have any challenges any other teacher has, over their contract, or over things they're asked to do, or over a discipline issue with their students, or really anything. So we are really a full service professional association for Christian teachers, and so that's who we are. And love to, if you want to know more about Christian educators, of course, you can check out our website. Again, go ahead and I'm looking at the chat here. All right, we've got Marianita from the Philippines. Wonderful, welcome. Sarah and Tanya, North Dakota, and there's Demetrius is hosting our chat, so say hello to him. And Rebecca from Modesto, sorry. Wendy, hey Wendy, I know you from Colorado. Thank you. And Nancy, Rosie. Hey, Rosie Bertels. Jennifer, Shauna, Jamie, Nancy. Wonderful. There's getting to be too many to call out, but thank you so much for being here. And while we're waiting for everyone to join us, I'd love to know also how many of you are in public or private schools. So if you just want to post also as you're sharing, go ahead and post whether you're in public or private school. That would help us just get a little to know how to gear our conversation a little bit. We're going to cover both issues today for both public and private schools, so it'll be relevant to any of you, but just help us know a little bit if our audience was overwhelmingly one way or the other. So it looks like we're getting a smattering, a lot of public, but some private as well. Christian school, yes. Okay, wonderful. All right, well, thank you for being here. As those of you that just came on, again, my name is David Schmoose. I'm with Christian Educators Association International. I'm really happy to be your host today, but honestly, I'm not real happy we have to have this session. As you know, Christians in our public schools are facing an increasingly complex and difficult legal landscape. And at CEI, we are getting increasing numbers of questions and inquiries from our members regarding all kinds of topics, whether it's the transgender issue, whether they can post their beliefs on Facebook or social media, or whether they can share them with their students. That's a question we get a lot. We also have some recent Supreme Court rulings that do or may affect schools, particularly private schools. And so we're going to see if we can get those questions answered today. And I've brought two amazing lawyers with me that will come on in just a minute here. But I heard recently about an investment banker who decided she needed an in-house counsel, so she interviewed a young lawyer. She said, Mr. Peterson, would you say that you're honest? Honest, replied Mr. Peterson. Let me tell you something about honesty. My father lent me $85,000 for my education, and I paid back every penny the minute I tried my first case. Impressive, she said. What sort of case was that? Well, Dad sued me for the money. I know that's sort of the impression we often have of lawyers, but fortunately for us, we also have good, honest lawyers, and I have two with us today. In fact, constitutional lawyers like Caleb and Jonathan do much of their work pro bono and are a lot like teachers. They work long hours for often very little pay. And so I'm so thankful for them and for American Alliance Defending Freedom and for Liberty Counsel, who they represent. So let me introduce them to you. Caleb Dalton, he serves as the legal counsel. Welcome, Caleb. for legal counsel with Alliance Defending Freedom, where he plays a key role at the Center for Academic Freedom. Since joining ADF in 2013, Dalton has represented both private individuals and government entities in matters affirming the fundamental freedoms of speech and religious liberty. In 2017, Dalton joined the Center for Academic Freedom, where he represents clients seeking to speak freely on campus, without fear of unconstitutional government censorship. With the Center for Academic Freedom, he has served as lead counsel on several cases, successfully representing students in eliminating restrictive speech zones and discriminatory student organization funding and recognition policies. Dalton earned his law degree from Regent University Law School, where he served as editor for the Regent Law Review. A native Texan, he currently lives in Northern Virginia with his wife and, get this, 8 children. His quiver is full, and I love that. So welcome, Caleb. Thanks for being with us today.
Thanks for having me, David.
All right. Now I'd like to bring on Jonathan Alexandre. And Jonathan is an attorney and senior counsel for government affairs for Liberty Counsel, a litigation firm dedicated to advancing religious freedom. Welcome, Jonathan. I see you there. And in religious freedom, the sanctity of life, and the family, in this capacity, Jonathan consults with and advises law and policymakers at the federal, state, and local levels across the nation. Jonathan is a presidential appointee, serving on the board of directors for the United States Agency for Global Media. Jonathan is also a nationally recognized speaker for the Content of Character series and serves as general counsel for the Frederick Douglass Foundation. Jonathan was formerly the assistant general counsel and public policy coordinator for the Massachusetts Family Institute in Boston. Alexandre developed the Massachusetts Attorney Resource Council, a network of pro-family Massachusetts attorneys. Jonathan previously worked for the Jerusalem Center of Public Affairs in Jerusalem, Israel, as a scholar in residence and as the United States Army's Judge Advocate General's Legal Center and School. He is married to his wife, Renee, and they reside in Waldorf, Maryland. All right, Jonathan, thank you so much for being with us. It's so good to have both of you. All right, and a little before we get going here, a couple of housekeeping matters. For those of you live with us, I encourage you to make use of the chat, as many of you are already doing. It's good to see so many of you posting there. Should you have a question, go ahead and post your question in the chat. We may get to it when you post it or shortly thereafter or during that conversation. We may get to it at the end, or unfortunately, we may not get to it at all. But if we don't get to it, here's the amazing thing. Right following this session, immediately following, will be a Zoom room discussion, and it will be on the same page as the session, on the session page. Demetrius, if you could post the session page link in case people got here from another direction. And on that session page, it'll be a link to the discussion room. And in that discussion room, Finn Larson, who is my predecessor, former executive director of Christian Educators, will be hosting that. And he, though not a lawyer, has been dealing with these issues for many years and can answer a lot of your questions there as well, most likely, if you don't get them answered here. But hopefully we'll be able to answer your questions. All right, so let me pray for us and we'll get going. Father, I just thank you so much for this opportunity. I thank you for Caleb and for Jonathan. And I thank you that we have the opportunity, Lord, to have this conversation and to equip these teachers to understand the law and understand their rights. And Lord, we do want to see your kingdom come in this nation, Lord, and around this world. But Lord, sometimes we do need to fight to protect those rights. And so we pray, Lord, you'd show us, give us wisdom how to do that well, give us understanding, Lord, and discernment. So we give this session to you. In Jesus' name we pray. Amen. All right. So what got my attention, or what kind of inspired me to put this session together, was the case of Peter Vlaming. And we did an article about Peter Vlaming in our latest magazine, Teachers of Vision. And we talked about the fact how almost 2 years ago, to almost to the day here, it was Halloween of 2018. Peter Vlaming was in his class. He's a high school French teacher, and he used a pronoun that cost him his career. Career, I guess, remains to be seen if it cost him his career, but it certainly cost him his job. And so that, of course, that pronoun was, he said her, and he was supposed to have said him, but he was referring to a biological female at the time. And of course, this case brings up the whole issue of transgenderism and the issues that presents to us as teachers in school. And so I'm happy to have with us Caleb, who is actually Peter Vlaming's legal counsel with Alliance Defending Freedom. And so, Caleb, can you start us off? And again, Jonathan, feel free to chime in any of these questions as well. We'll have some, of course, specifically for you in a moment here. But Caleb, can you tell us more about Peter's case and help us understand why this is so important for educators?
Absolutely, David. Thanks so much for having me. Thank you to Christian Educators Association International, Teach for the Heart. That's for putting this conference on and highlighting this important topic. Like you said, I think at the beginning, you kind of wish we didn't even have to have this conversation. And I'm right there with you. And I think Peter is as well. But I think going back 2 years ago to when this all happened, it will give a little framework for understanding why is this important. So 2 years ago, students were protesting at West Point High School. They walked out of their classrooms protesting, and this wasn't a protest for, against guns in schools or any other of the major hot button issues. It was actually they were protesting because their favorite teacher was fired. And that was Peter Vlaming that you mentioned earlier. And there's a reason Mr. Vlaming was one of the favorite teachers at his high school, and it's not because he was a jerk. It was because he loves his students. He cares about them. He had the student in question and been teaching her for 2 years. And she came to him over the summer and said she wanted to transition to identify as a male. And in that case, he said, he tried to ask questions, understand what was going on, talk with the parent. And they asked if he could use her new preferred name. She wanted to have a what would be typically more of a male sounding name. And so he said, sure, I can use that name. He teaches French, so they actually use French names in class. And so he actually had the entire class pick new French names so that this one student wouldn't feel singled out since she was switching her name. Did everything that he could to accommodate this student. But what he couldn't do was use the male pronoun to refer to what he knows to be a female student. His conscience wouldn't let him do that. As a teacher, he knows that words have meaning. And then when you use a word, it means something, and he could not affirm that ideology. He believes everybody has the right to have their own beliefs about this, but all he's asking is not to be forced to express a belief that he doesn't hold. So that worked fine for a few months. And then you mentioned kind of in the intro that he got fired for a 3-letter word, right? Well, that actually occurred as an accident. They were having, like I said, this worked fine, him using the preferred name, not using the female pronouns anymore. He was just avoiding use of pronouns, which is pretty easy to do in personal conversation. And they were having for Halloween, so apropos of our current time, they were having an experiment where they were wearing virtual reality goggles and exploring the catacombs of France. So they're teaching French, learning about French culture. It's Halloween, catacombs where people were buried. All worked out great. Well, this student was walking down the hallway with virtual reality goggles on, was about to run into the wall. And Mr. Vlaming, who had the student as a female for 2 years, he instinctively shouted out, "Don't let her hit the wall." And those 3 words, HER, is what led to his firing. They gave him an ultimatum and said, you have to use these words. You have to say he, him, his. And if you don't, we'll fire you. And if we think you're even attempting to use her preferred name instead, then they would fire him. And that's what led to the current case. And why is this so important to educators? It's because, well, one, they may run into this same situation. And whether or not you agree with Peter's position on how you use pronouns and what they mean and what that means for your conscience, what it does mean, it raises the question, what can the government force you to say? Because this is about being forced to say specific words. It's not about anything he did. It's about what he didn't say and what he refused to say in the future. So that's why it's so important for educators, is the power of the government to come in and tell you, can you speak these words? This is not curriculum related. This isn't telling him what he has to teach in the classroom even. This is his interpersonal actions outside of the classroom with other teachers, even outside of school. And if the government can reach that far, we're in a place where we're losing a lot of freedoms. And that's why his case is very important. And we hope that we can establish that there is a line that the government can't cross here.
Yeah, it's well, of course, we want to have a tremendous amount of compassion for these kids, and Peter, it seemed like he did have very much compassion for this particular student. Obviously, these kids who are struggling with gender confusion or dysphoria are in need of our compassion, right? They're hurting and they're desperate and they're probably very broken. For the most part, but at the same time, the forced acceptance of this idea, this sort of transgenderism philosophy, which amounts to very much like a religion. It's not particularly scientific. It's just based on feelings for the most part, and now the government is basically compelling us to go along with it. And wow, that's frightening. Are there other cases like this around the country that you're seeing that we can kind of deduce any principles from that would guide us as teachers, and at least in terms of how the law is going?
Right. So we also represent Professor Merriweather at Shawnee State University. He was threatened with discipline for a similar incident. He wasn't actually fired in that case, but he got a letter of reprimand in his case. He's a philosophy professor, and again, a male student in that instance wanted to be referred to as female. He offered all kinds of compromises, including not using pronouns, using a preferred name. Nothing was acceptable to the school or the student, so they reprimanded him, and then the student is in a different class now, so it's not currently an issue. But based on that, we have filed a lawsuit. And that at the federal district court, the court dismissed his case. We have that on appeal before the Sixth Circuit right now. So, and then you mentioned it being almost like a religion, and that's where the concerning part comes in. We also represent Dr. Josephson at the University of Louisville. He was the head, the chief of the Division of Child and Adolescent Psychiatry and Psychology at the University of Louisville for 15 years. So he's well respected in his field and has over 35 years of experience dealing with psychological and psychiatric issues. He just expressed his professional opinion at a Heritage Foundation panel. And Heritage Foundation is a well-respected think tank. Mm-hmm. And because he expressed his opinion that these issues should be dealt with primarily, especially in adolescence, at least at a psychological level, rather than implementing harmful puberty blockers and cross-sex hormones and even irreversible surgery, that we should try other methods to deal with the psychological distress that students have. He was actually eventually fired from his position as the chair of psychology there because of just expressing his opinion at an academic conference. And his opinion's based in science, it's based in reality, but because it goes against the current religion of gender ideology, he was fired for it. And that's a scary place for our society to be in. And I think that's another reason people need to stand up and be loving toward those certainly who have these issues, but not abandon reality, because it's not loving to affirm something that's not based in reality like this, or to start firing people like Dr. Josephson and Merriweather and Peter Vlaming, who are simply speaking the truth.
Yeah, absolutely. Absolutely. Jonathan, would you have anything to add to what Caleb shared?
Yeah, absolutely. And so one of the things Caleb mentioned is, government controlling speech in different venues. And of course, some of these cases occurred in school with the Vlaming case, but also this professor who's doing something on his own time outside of the bounds of a classroom. And still you see government reaching into that area. It's a troubling development when it comes to what was otherwise protected speech. A professor or teacher speaking on their own time in their own public sphere. It could be on the internet, for instance. So social media should play by the same rules of the First Amendment, where a teacher should have the ability to express ideas and still retain the full measure of First Amendment protections, even if the subject is controversial. So teachers don't lose their constitutional privilege to believe a certain way, but also express that in the public square. And so we're seeing not only in the classroom, but in these public settings as well, and even on the internet, the new cyberspace of the public square, teachers being challenged for expressing their exchange of views. And so we continue to make the argument that the First Amendment isn't devoid in areas of that kind, that it does impact the public square as well on the internet, and that teachers do have the right to express themselves, especially if these ideas are of public concern.
Absolutely. And that whole issue of free speech, there was a case just a few weeks ago out of the UK, and of course they have a different legal system, but there was a teacher who said, was expressing concern over the transgender philosophy that was being implemented in her son's school. She happened to be a teacher also at a different school. She didn't mention that she was a teacher in the post. She didn't even use she used her maiden name rather than her name that everyone knew at the school by. And yet there was an anonymous complaint by one of her social media friends that she had said these things, and there was an investigation, and she was fired from her school simply because the school didn't believe that they believed she would be bigoted in her interactions with with students that were LGBTQ, and so this gets to be a real dicey issue, because I think most of us would probably agree that if a teacher on social media said, "Oh, here's pictures of me at the White Power rally this past weekend," we'd probably say, "Oh, maybe that teacher should be fired," right? I mean, there's sort of a limit to free speech, at least in terms of what we think about our public school teachers or private school teachers or what have you. So, and the cultural left would say that's equivalent, right? They would say someone online saying that they don't believe in transgender ideology is the same thing as someone, going to a White Power rally or being a racist. And so what kind of guidance do we give our teachers in terms of how to navigate that? Because we certainly don't hold those things to be the same. But we're in a sense, you could argue maybe we're kind of losing that culture war right now, right? And so what do we say? Any thoughts on that?
Yeah.
Go ahead.
I think the concern you present is very relevant, and especially in that situation, in situations that I'm sure many teachers across our country can face, the goalposts are always moving. It's always a big cultural standard as to what's in vogue and what is culturally appropriate. And not only is the standard shifting, but the audience is broader, and so you're having a more difficult time finding out what's offensive to whom and what you can say and when you can say it. And so the ultimate general principle of law still remains that if it is an issue of public concern, if it's done on your own time, in your own setting, that it ought to be protected by the First Amendment. Teachers don't operate devoid of a situation where the First Amendment gives them the right to believe a certain way and also express that in their public setting. And so we'll continue to make the argument. Of course, teachers ought to use discernment, but even that discernment is playing in it's difficult to really know how to approach a situation with complete wisdom, as there is a double standard in the type of speech that you can use and how you can use it. Nevertheless, we continue to make the argument that the First Amendment ought to protect the teacher's ability to believe a certain way and express that.
Yeah, and I'll hop in there with just a quick kind of example of. And I'll caveat this is not legal advice. I'm just giving a general principle of law, but hopefully it will help frame and help student or teachers understand kind of where the current law is. And so one of the first cases actually talking about what are the free speech rights of public employees. It was a public school teacher. It was a case called Pickering versus Board of Education. And in that case, a public school teacher wrote a letter to the editor that was very critical of the school board. School board was upset and they fired him, and it went up to the Supreme Court, and the court said no, he wrote a letter to the editor in his own time about a matter of public concern. So this was a matter of public concern to the community, and when you're writing in your individual capacity, not as your capacity as a public employee or speaking in that capacity, and you're talking about a matter of public concern, the court has said, well, that speech is definitely protected. Now, they will apply what they call a balancing test after that to say, well, would this, even if it's protected, would it disrupt the learning environment so much that we couldn't continue to have an educational environment? And that's where maybe your example of somebody who attends a KKK rally or expresses racist messages, if that is to the extent that it completely disrupts the educational environment, that students can't learn from that teacher, then obviously the school board has an interest in firing them. Right. But simply making a public statement, especially about a matter of policy, and the court said, what is a matter of public concern? They said it's anything that relates to a matter of political, social, or other concern to the community. So If it's a matter of public concern that you're speaking about in your personal capacity, it should be protected. That doesn't mean you couldn't face repercussions, but you shouldn't be afraid to stand up and speak the truth in a loving way using discernment. But if it's a matter of public concern in your private time, the law says you have the right to say it, and you should be able to.
Yeah, and hopefully, there's a lot of self-censorship, I think, going on out there, and sometimes we do what we have to do, right, to stay in our mission field many times. But I'm concerned that the level of self-censorship is rising to the point that we may lose that argument in the culture, and the law may go in a way that we don't like. But hopefully we'll keep contending and keep making those arguments that that this new transgenderism worldview doesn't make sense. And I think there's a lot. By the way, if you would like to get equipped on that issue, we have a website we've developed. It's at ceai.org/gender. There's a lot of great resources there, both from a scientific, therapeutic, also legal, philosophical perspective that will help you sort of get equipped on this issue, because this is a battle I think we have to fight. There's a question that comes in that sort of kind of is the next question I was going to ask you anyway. So D asks, can teachers in public schools be forced to use LGBTQ curriculum? And so what happens when you're minding your own business as a teacher, and all of a sudden you open up your sex ed lesson that you have to teach, or your history lesson or whatever, and you find it's got pro LGBTQ messages in it? What do you do as a teacher, as a Christian educator?
Well, certainly in the public school setting and in most employment settings, Title VII, the religious accommodation that one can ask should be one of the first things that a teacher requests. Certainly in the sex education context, as more jurisdictions are providing more expansive view of what sexuality means and teaching more extreme sexual actions to children at a younger age, one can make the argument that this violates my sincerely held religious beliefs, and ask the school for a proper accommodation, for a reasonable accommodation. And the school should be able to give that accommodation, which is another teacher coming in and saying, well, I'm comfortable teaching that material. And so I think first, a teacher should ask for an accommodation. If we're running into a situation where no teacher feels comfortable teaching that material, then I think the onus is on the school board to realize, well, maybe this isn't curriculum that is appropriate, since we can never, we're not able to find any teacher that's comfortable with this material.
Yeah, you would hope.
but certainly the first thing a teacher should ask for is an accommodation based on Title VII, sincerely held religious belief protections. Hopefully it'll be favorable for them in that instance.
Yeah. Just because the law is that way doesn't always mean, that that's the best choice. Let me give you an example. Out here in California, we have a sex ed law that is very radical, called the Healthy Youth Act. And basically in the text of the law, it says something along the lines of, if the teacher is unable or unwilling to teach this curriculum, the school can bring in outside organizations to teach a curriculum. So I, as a Christian teacher, now I'm faced with this dilemma of, do I teach it myself, or do I turn my class over to Planned Parenthood? Right. And I just can't imagine as an educator having, turning my class over to Planned Parenthood. Right. And so this is but yes, let's be clear about that. You can request religious accommodations. And if you need legal help doing so, there is legal help for doing so. So that's a good answer. All right. Let's, we have a lot to talk about. So I know there's some questions coming in. We'll try to get to those maybe at the end. But another issue I think we need to talk about is critical race theory. And the fact that many of our educators have come back to school after this very tumultuous summer and are being required to attend racial sensitivity trainings that are often well-intentioned and maybe helpful in some cases in terms of our ability to connect across cultural racial lines or to understand our own implicit biases. But they often, unfortunately, place way too much emphasis on group identity, assigning blame, making assumptions about what's in people's hearts, and even suggesting that it's racist to encourage students to have certain good and biblical character traits that some associate with whiteness, for example. Jonathan, I know you've worked on this issue a bit. Give us some perspective on it and how teachers should respond if they find themselves in those situations.
Yeah, so place it in context is the first thing. So critical race theory, it's same Marxist sort of principle, where Marxism is sort of an economic framework that says, if you're a capitalist, you're an oppressor, and everyone that isn't in this capitalist way of making money is an oppressor. So dividing society into two classes, where the capitalists are always wrong, and it has to be a more communistic, social-based way of having funds spread out through a community. This is Marxism, but using race. So it's saying that if you're white, you're always wrong. Of course, that's not true. But it's saying that because of historical realities, often in this country, and white people being in the majority, that they have always created a system where they will always be on top and Black people are always underneath. So a system of dominance and oppression. And as you mull over these ideas, they're frankly outrageous ideas. There is no truth to what they're positing. And, you've given them more credit than I would. I don't think it's well-intentioned. I think it's ultimately pitting society against one another and pitting race against one another, bringing about, a different view ultimately of what society ought to be, and using this issue of race to further divide society. The difficulties, as you mentioned, is now being introduced in teacher training, ultimately with the intention of having that trickle down through the curriculum. And that's what the Marxists have done for decades now. It's been in the academic settings where they've put forward these ideas, and we're seeing them develop certainly in society today. And so since it's been brought about through the academic setting, I think it's also in the academic setting that we should be challenging these ideas, that we don't abandon or abdicate our role in training and shaping the next generation, and don't allow what is frankly outrageous doctrines of oppression and seeking to pit one group against another, that we don't allow that to become prevalent, but using the opportunities that we have to deal with the realities of the different outcomes that perhaps race has historically had in this country, but address it in ways that are empowering. Talk about the Frederick Douglass stories, men like Frederick Douglass, who was a slave and rose to the highest levels of society because he didn't feel sorry for himself and thought that had the full faculties, and African Americans, even those who were enslaved, had the full faculties to compete equally with their white counterparts, and never using that as a stigma against himself to hold himself back. Using stories like that are great ways to compete with the narrative. And I think the impetus is in the academic setting to present counter ideas to critical race theory. One of the things I certainly credit the Trump administration for doing, the Office of Management and Budget recently releasing a memo saying that they will remove critical race theory from the training that federal contractors and federal employees and federal agencies get. I think that's a strong move, pushing back against what is a disruptive, damaging narrative that ultimately wants to pit two groups against each other.
Absolutely. Well said, Jonathan. Does the Trump executive order apply to public schools in terms of their trainings?
So the text of it says that it will further develop directives, and hopefully the idea is that those directives will reach Department of Education. Haven't seen anything concrete saying that as of yet, but we will take the approach of testing the bounds of it. One of the things that the other side has done, they've been good at doing, you'll remember the Department of Education transgender sexual orientation directive that came out under the Obama administration. The ACLU immediately went out and started filing complaints, sort of testing the bounds of it and seeing if they could bait the federal government into enforcing that directive further than what I think the directive initially wanted to.
Got it.
So that tactic, can be something we'll consider, where we're testing the bounds, seeing if they will address this in other areas, especially in the school setting. Certainly, for it to have come to the government's attention means that there were enough people complaining about it and saying that this isn't right. And so the more stories that teachers can bring of how it is disruptive to the classroom and disruptive to their curriculum, disruptive to their training, the more stories and complaints that we can have demonstrating to the federal government that, this is an area that they should speak on, certainly we should do.
Right.
Ultimately, I will say, just as a last point, of course, it's done best locally. And so with school boards and developing the training and curriculum, that's certainly a way, using what the Office of Management and Budget has done, that's certainly a way to begin saying, hey, this isn't the common narrative that this nation's going to accept overall, and certainly something that here in our local school board we should reconsider doing.
Well said. So if a teacher, can a teacher on their campus, let's say they see something scheduled, or they know their principal is considering having a professional development on this, could they use Trump's executive order and say, hey, look, here's an executive order about federal funds, or federal programs. We get federal money. And even if the executive order doesn't explicitly apply to public schools, could they say, hey, this is something for us certainly to be concerned about. Here's the federal government has banned it, essentially. Why are we doing it?
I think it's probably less of legally whether they can do it or not. I think it certainly does help in the counter narrative. If they are bold enough to present the counter narrative, something like that, and the wording of the document itself was strong in decrying some of the things I mentioned, how it is essentially making folks, we pride in their country, and it's ultimately an un-American, critical race theory is ultimately an un-American point of view. I think a document like this can give them the fodder that they need to make the argument, whether or not it's successful or if it's a strong legal case. I think that's we'll have to wait and see if it'll be effective.
Yeah. Okay. All right. Thank you, Jonathan. Caleb, would you add anything on that?
I think Jonathan covered it well.
All right. Excellent. Okay. Well, turning to a new subject here, something I'm very concerned about is the increasing prevalence of biological males being allowed to compete in girls' sports. So, Caleb, I know ADF has been involved in these issues, particularly in Connecticut, especially. So, can you give us an update on where we are and why that's a concern and what you guys are doing?
Absolutely. Well, it's a concern because it's both a safety issue and a fairness issue. It's a safety issue for women who have to compete against biological males who have denser bone structures, larger lung capacity, and just generally larger frames and the ability to harm them more. Competing against females who, on a whole, there's physiological differences that put them at a disadvantage, and that's demonstrated in Connecticut, where we represent 4 female athletes who have had to compete against biological males, specifically in track and field. And in the last 2 years in Connecticut, those females have lost out 15 championships in the state to biological males who have taken their places on the podium. Over 85 opportunities to participate in higher levels of competition, to move on in competition, because those males took 85 different spots in different races. And those 2 males actually hold now 17 individual women's meet records in Connecticut. And those are now records that females are going to have little hope of ever breaking, just because of the physiological differences in the male and female bodies. And these athletes train hard. They do their best. They are fighters. And it's very discouraging, not to mention unfair and unsafe, to require them to compete against males with the physiological differences between the biological sexes. Now, where's that at right now? That case has been pending for a while. The Department of Education under the Trump administration has shown an interest in this matter, and actually we filed a Title IX complaint against the schools and against the Athletic Association. And the Department of Education has issued a letter of impending enforcement action against those schools for violating Title IX, because the whole purpose of Title IX was to create fairness in education for women. And it's absolutely not fair to require them to compete against biological males. It does not give them an equal opportunity in education or an equal opportunity to compete on a fair playing field. So that's where Connecticut is at. There's procedural issues still going on. There's lawsuits pending, Department of Education investigations pending. But that's actually not the only case. So some states have sought to remedy this situation. So Idaho has actually passed a law, HB 500, to attempt to help with this and say, look, if you're a biological male, you compete on the male team. Biological females compete on female teams. And the ACLU has filed a lawsuit against that. And a federal court issued a preliminary injunction. So it's not a final ruling, but staying that law, saying that Idaho can't require males to compete on male teams and females. That is on appeal up to the Ninth Circuit. But again, it's kind of, there's no final decision on that yet. We'll see where it goes. But those are 2 actions that are pending on the athletics issue right now.
Okay. Yeah. And of course, my wonderful state of California announced that they would boycott any state travel to Idaho because of that issue, which is ridiculous. But anyway, so if you're have a PE teacher, a coach, and they are met with demands for a student to use a locker room or play on a team that is inconsistent with their biological sex, how would you generally advise those coaches or PE teachers in those situations?
Well, if you run into a situation where you feel like you may have legal issues, always seek legal advice is the first thing. A PE teacher and a coach it's in a difficult situation because in general, you may or may not be being required to do something that violates your conscience. If you're talking about an affirmative action of your job is to monitor the showers and locker rooms, and you're being required to allow a male into the female locker room, well, certainly that could be an issue that violates a teacher's conscience. You feel like you're acting in an unsafe way. And if that's the case, then seek legal advice. There are potential Title VII protections. As Jonathan mentioned earlier, Title VII is federal employment law that protects a religious liberty. And that basically says if your employer is asking you to do something that violates your sincerely held religious belief, then you need to request an accommodation. You need to tell them, look, it would violate my faith to do this action that you're asking me to do. Can you provide me with a reasonable accommodation? And that's certainly a protection that's out there. Every situation is going to be different, though. So I would certainly suggest seeking legal advice if that's something you feel like you can't do.
Okay. Thank you, Caleb. All right. Well, this issue of the sports teams and the gender issue, of course, brings up a recent Supreme Court ruling. It's actually kind of a pair of rulings. And some of these rulings have issues also for private schools, so we're going to get to that as well. But the recent Bostock and Harris rulings said some interesting things about gender identity that at least were troubling for me. How might those cases, give us a kind of a summary? Maybe both of you can kind of tag team a little bit on this, but give us a summary of what those cases said about gender identity and how that could potentially find its way into the public schools or private schools, or will it? I guess is the question. So, what happened in those cases?
I think ultimately, we have a negative view of what the court did in that case. I think they ultimately played the legislature in saying that the word sex, as we've always known it to mean biological sex, now, at least in the Title VII context, applies both to sexual orientation and gender identity, which means that the word sex and how it's interpreted through hundreds of statutes on the book, certainly in Title VII, has a very expansive and ever-changing standard because it no longer means male-female. It could mean transgenderism or sexual orientation, the many permutations that sexual orientation comes about. So it's obviously a bad decision whenever the court comes out and plays legislature in that sense. In the context that it was used, and of course, it being an ADF case, Caleb will be able to speak specifically of how it applied. But in the context that it was used, it was effectively saying that an individual, when hiring or maintaining an employment, if found to either fire that individual or treat, based on that individual's sense of it, discriminatory, that individual based on their sexual orientation or their transgender identity, that they're not allowed to do that. That Title VII would ultimately protect that person's identity, even and above that individual organizations or certainly that governmental entities, feelings on the issue or their beliefs on that issue. The court did something well, however, in upholding an area of law that does provide a ministerial exception, in reaffirming that certainly in the context of a person doing a ministry work or being a critical part of that religious organization's mission, that the organization can have a way of interpreting sex or biological sex to mean what it actually means. And so I think in one way it did the right thing in allowing there to be further protections for Christian organizations or Christian schools, maintaining the ministerial exemption. But overall, I think the case was poor in its decision in that it reinterpreting the word sex to mean something that the legislature never meant it to mean, ultimately has really bad, really bad results in the Title VII. And it'll be interesting to see how far that stretches if it'll apply to Title IX context as well.
Okay. And just to give a little background there, when we talk about Title VII, Title IX, we're talking about the Civil Rights Act of 1964, which barred discrimination, and it had various sections. And Title VII, as Jonathan just pointed out, was about employment law, right? And Title IX is about education. And so we now have this definition. Now we have gender identity as sort of as a legitimate thing, essentially, entered into Title VII jurisprudence, if you will. But the question is, will that definition, will that idea of gender identity now bleed into Title IX and be applied to schools? Now, my understanding, there was some language in the decision that maybe is a bit of a bulwark against that from happening. Is that the case?
Possibly, yeah. I mean, it is an interesting decision, and it's a hyper technical decision in some ways, and its reading of the parsing out different words of the statutory language of what does because of mean, what does sex mean, what does discrimination mean. And one of the things that the court didn't do is they actually didn't say that the word sex means anything other than biological sex. But what it did say is discrimination because of sex means if you consider sex at all. So let's say you have male and female restrooms. Well, you're considering sex. You're treating men and women differently. Under a technical reading of the law, I don't see how that's not discrimination. Now, I don't think the court is necessarily going to go that far, but it's a very odd ruling in that they basically said if you recognize differences between the sexes, then that's discrimination. And the court's never done that. And one of the seminal cases on sex discrimination, the University of the VMI case in Virginia, where the court clearly said, look, no, you can't discriminate based on sex and deny equal opportunity based on sex, but you can recognize the inherent biological differences. That was actually a case, if I recall correctly, by Justice Ginsburg. And she said, look, you can recognize that men and women are different. And as long as you be treated equally, you don't have to deny reality. And I think that's what we're on the verge of here. And the court's teetering on this. Where are we going to go from here? Mm-hmm. Are we going to move down this road of we're going to deny that there's any differences between men and women when we all know there obviously are? Mm-hmm. Or are we going to stay the course and say, look, obviously sex discrimination is wrong and that if you're actually discriminating against men or women because of their maleness or femaleness. But if we then go beyond that to a subjective based standard that's not based in biological reality, there's really no line for the court to draw beyond that. So I don't think we know where this case is going to go. We don't know how it will be applied in the future. Certainly there will be some who try to push the boundaries and use it to advance their agenda. But the reality is we just don't know. We'll see in the next few years as those cases play out.
Okay. Thank you, gentlemen. Last sort of major topic I want to bring up, and we'll see if we can get to some questions. For our private school friends, there was a case this last session of the Supreme Court called the Espinoza case that whether or not they struck down the Blaine Amendments or just sort of neutered them, I'm not really sure. Maybe you can enlighten us. But Blaine Amendments were these constitutional amendments in about 30 different states, as I recall, that said that no public money could ever go to private schools. And they were sort of anti-Catholic laws left over from the late 1800s. But now in those states, they have prevented any kind of voucher programs or any ways that the governments can implement school choice where people can take state money and take it with them to a private school. Now, apparently, those Blaine Amendments are neutered, at least to an extent. What does that mean? Is that accurate? What does that mean for us going future? Are we going to see a potential explosion of voucher programs, letting families go to private schools in those states?
Yeah, I think generally one thing, both this case and the timing of the case couldn't have been any more perfect. I think COVID did something to shake up what has been, government-only education done in the way that it's always done. I think there's definitely been differentiated learning on the micro scale, but also on the macro scale as well. And so this case coming around and, essentially effectively saying that potentially individuals will be able to take their taxpayer funds to parochial schools, increasing school choice. If you interpret the case to mean that, I think that's a strong move. I think there's certainly a trend going in that direction, that individuals are realizing that the 40% of their taxpayer funds, 40% that they pay towards their schooling, that money should follow the child, even if it means that they go to parochial schools. And where the Blaine Amendments before were basically saying that no government aids could go to parochial schools, even if it's carried by the child or even if it's carried through a voucher to that school. I think what this case ultimately can stand for is peeling back what has ultimately been that standard, keeping money away from parochial schools. I think the trend, both as we see culturally, moving away from strictly public school adherence to now more alternative educations. I think a case like this could prop up or help foster what was ultimately a good decision in school choice.
Yeah, I'd agree. And just as a real world practical implication, what is this going to mean? Well, we've already seen at least one consequence. At ADF, we represent the Catholic Diocese of Burlington in Vermont. And Vermont has a dual enrollment program where they allow students to attend college at public. If you're a high school student, you can go to college, public expense. You get dual enrollment, high school and college credit, right? Well, they allowed any students to participate in that program unless you were at a religious school. So our clients were at religious high schools, and they were denied the ability to go to that, use that dual enrollment funds. And because of the Espinoza case, the Second Circuit has halted that, and now our clients can go forward and have equal access to that funding, because there's absolutely no reason you should deny, the Catholic high school students the equal ability to attend college as the public charter school.
Right. Okay. All right. Well, thank you, gentlemen. This has been a great discussion. I've got one more question for you, but I want to hold that to the very end. I want to see if I can just get a few questions in here with the time we have. We don't have time for very many. Heather asked, going back to the discussion about curriculum and transgender names and things, what about a teacher being expected to use a preferred name when the child's parent doesn't support the child's gender switch? Any thoughts on that?
That is a difficult situation for sure, and obviously a lot of the difficulty is going to come into play with what is the school administration telling the teacher, because often it's a situation like that. Administrators and school councils will become involved. And ultimately I think the parents need to be able to step up and assert whatever rights they may have over their child's education. And to the extent a teacher is affirming the parents' rights, then I would affirm that as doing the right thing. Now, whether or not they're protected, that could come into play with the interactions with the school administration. Certainly a difficult situation, and one I would encourage them to seek legal advice on.
Yeah, and I would add that it also depends how the state law is written, right? I mean, in our state out here in California, we have a very radical state law that essentially says no, even if the parent doesn't agree, it's that child's choice that determines it. And so we would hold that to be egregiously morally wrong. But the fact of the matter is, if it's a go against state law, you are putting your job at risk by not complying. And so it remains to be seen if groups like Liberty Counsel or Alliance Defending Freedom can help you in that case. But that is certainly a concern. Very, very interesting question came up from June. In Ohio, do I have to avoid biblical references during my professional development presentation at a Christian school if I paid if the program is paid by state auxiliary funds? You get the question. So she's got a PD, a professional development she's doing at a Christian school. It's paid for by state auxiliary funds. Can she use her biblical references in the training?
But the pushback that you're obviously seeing, what the other side would argue is that that's excessive government entanglement. And so there would be a pushback against that from the other side. Of course, there are often creative ways to insert biblical references in any curriculum, anything that is on point and relevant to, when you're talking about history, when you're talking about, especially in English class and literature, and the wealth of literature that comes out of Scripture, and basic proverbs, comparing that to Aesop's fables and common things that Scripture does speak to, but have become commonplace in our culture, and also can be weeded into a curriculum. Certainly you're protected in doing that. You are able to do that. It becomes, and the situation presented becomes a bit dicey there if there is pushback. If an individual wants to raise a claim saying that there is too much entanglement between your faith and what you believe, and what now the government is speaking through you, you being an employee of the government. So that, that's the tightrope you'd have to walk and balance. But there are certainly creative ways where you can infuse the historical and literature significance that Scripture has had throughout time.
Okay. All right. Wonderful. Thank you, gentlemen. Last question. I said earlier, what are you seeing out there that we can end on a hopeful note with? Anything out there you're seeing that's encouraging to you despite the challenges we're facing?
Sure. So this isn't something I see out there. It's something based in reality. And I think the most encouraging thing is not some pie in the sky hope that's not based in reality. Reality is that there is evil, but there's also good, and good will triumph. And one of my favorite encouraging things that I actually encourage myself with is, it's not actually from Scripture, but I think it's very scripturally and biblically based advice. It's something Samwise Gamgee said to Mr. Frodo and the Lord of the Rings, one of my favorite characters. And the quote is a little bit long, but I hope it encourages those listening. And I'm going to go ahead and read it because it is my word of encouragement to them. It's like the great stories, Mr. Frodo, the ones that really mattered. They're full of darkness and danger. Sometimes you didn't know how it would end. How could the ending be happy? How could the world go on back to the way it was when so much bad had happened? But in the end, it's only a passing shadow. Even darkness must pass. A new day will come. And when the sun shines, it'll shine out the clearer. And now, folks, in those stories, they had lots of chances of turning back. Only they didn't. They kept going because they were holding on to something. That there's some good in this world, Mr. Frodo, and it's worth fighting for. And I'd encourage you, there's good in this world. God has given you a calling. It's worth fighting for. The shadows will pass, and ultimately the grave is empty, and the world will not bow before Christ, and we will all glorify him in the end. So keep fighting for what's good.
Wonderful. Wonderful. Thank you. Thank you, Caleb. What about you, Jonathan?
Yeah, I think the encouraging news are the ones that don't make the headlines. They're the day-to-day, Monday through Friday work that the teachers and educators do. It's the work that spans throughout the length and the breadth of all of American education. The call that God has placed on the teachers, the tutors, the coaches, the teachers' aides, the administration, the staff, everyone who is involved in the system of helping kids and raising up the next generation. They do an incredible job preparing this next generation to be upstanding citizens, but also to be trained academically. And that's something that's near and dear and close to my heart. My father was an educator. He was a psychologist in the Boston public school system, and he won Educator of the Year, but was a conservative Baptist pastor at the same time. And he would go to the State House and argue on the basis of religion and the basis of his biblical values while still being a psychologist in a public school system. And he was able to do that in such a manner that was winsome, still using his prophetic voice in the public square while still maintaining his duties in his secular capacity. And today I still run into people whose lives have been changed by the work that he did, but also the faithfulness that he had to the gospel in doing that work. I think that's certainly true of the folks that are watching us, and certainly true of the vast majority of teachers that see this as their calling, see this as something that God has risen them to do. Even if it doesn't make the headlines, it makes a real difference, and it's a difference that we are all very grateful for.
Oh, thank you, Jonathan. I have to get you guys your own sessions next time to preach to us. Those are beautiful comments. All right. So a couple things we want to do. One, we got some giveaways to give away. And so the way you enter in for the giveaways, of course, is you provide feedback to our session. So if you go to the session page, at the very bottom is a banner that says leave feedback. And if you do that, every time you do that for one of our sessions, you get entered into the drawings to win prizes. If you give 10 I don't know, if you do it 10 times for 10 sessions, sorry about that, then you automatically win stuff. And so that's super cool. And I've got to announce a couple winners. We're giving away sort of our grand prize package for on this session, and that is a full professional membership in Christian Educators Association that comes with liability insurance and job protection benefits and the unlimited legal consultation, all that for a full year, and that's a $239 value. And our winner for that is Rachel Johnston. Rachel Johnston. So congratulations, Rachel. If you're here on this session, great. Send a email to linda@teachfortheheart.com to let her know you've won. You can also send it to me at dschmoose@ceai.org. And I also would say these are kind of, you have to be present to win kind of prizes, and not necessarily on this session, but sometime over the course of the conference, we need to hear from you, Rachel. But if Rachel never sees this and her friends never know her and let her know, and she doesn't claim it, it's still up for grabs. I still like to give it away. So if you would like to be sort of in the mix to win a full year free membership to Christian Educators Association, please send me an email. And Demetrius, if you could post my email address in the chat box, dschmoose@ceai.org. And I will, if Rachel doesn't claim it, I will pick from one of the ones that emails me, and we want to definitely give that away. The next prize is one of our CEI posters, and there's one for primary, one for secondary. And Carlene Hakama, you've won a poster of your choice, so you can either choose the primary or the secondary poster, and let us know what grade you teach so we can get you the right one. All right. And but don't forget, right immediately following this session right now, join Finn Larson in the online discussion. If you just go ahead and go back to the section page, click the join the discussion link, and you can go in there in a Zoom room, and you can get, anytime you didn't get questions answered, any questions you did not get answered in this session, you can get answered there most likely. And so please enjoy that for the next half hour or so. And then don't forget, join us at 1 o'clock. Linda's going to be helping us how to tame our out of control to-do lists. So don't miss that session as well. All right. Thank you all for being here, and have a wonderful day. And thanks for participating with us here at Rise Up.